basically, what I want to do is try and clarify why are professional teams exempt from the from being a monopoly?
The National Football League is not exempt. Only baseball is exempt, and that's because of a bizarre series of opinions by the United States Supreme Court. But the National Football League is clearly, obviously, and has been adjudicated many times as a cartel, as a monopoly, and as such it is frequently subject to triple damages under the antitrust laws. There are basically two laws, the Sherman Act.
Which they were found guilty of by the USFL, against the USFL.
Yes, they're always found guilty of being a monopoly. It's an obvious thing. The National Football League has been denying monopoly status for 40 years. On the issue of whether it is a monopoly, they always lose in court. What happened in the USFL case was Meyerson and Trump and everybody did not prove the damage, and so the jury only gave them the $1.
So basically, the jury awarded them because the $1 that they were guilty, but they couldn't really account for the damages with the TV contracts and the like. So that's
I
your
think
assessment.
what happened was Meyerson. Well, in the history of the National Football League, it's always been a monopoly. It has always had exactly the same law firm, Covington and Burling of Washington, D.C., defending it against antitrust cases. Covington and Burling is a terrific law firm. They've had a lot of practice in the antitrust courts because of the National Football League. They've had cases all over, Minneapolis, New York, everywhere. So they've had a lot of practice, and they know exactly what they are doing in an antitrust case. An antitrust case is probably the most difficult kind of case for a lawyer to try, for a lawyer to litigate. So that Meyerson, on behalf of the USFL, was up against highly skilled, experienced lawyers, and even though the NFL was obviously a monopoly, still is, was behaving like a monopoly, was working the television market and everything else as a monopoly does, based on its enormous concentration of an economic power, Meyerson was unable in the trial of the case to show how that behavior injured his clients. That there's a second problem, and that was that the jury did not like his clients, Trump, Herschel Walker, and so on. They were very unappealing individuals, very difficult to present as victims of anything. And what you need an appealing, victim, an appealing plaintiff. In lawyers' jargon, they say, I need a good plaintiff, and he did not have a good plaintiff. He had some good ones, but when Trump came in, they lost all of the emotional appeal of the case.
And do you think that the $1.6 billion they were seeking was certainly ludicrous to the jurors, especially even in 1986?
No, I don't think it was the amount. I think it was the people that were asking for that amount. The $1.6 billion, there was, as I understand it, some economic support for that. When you look at the National Football League now, or even then, it's the single greatest economic engine in the history of the sports industry. It has been for many years. So that $1.6 billion, no, I don't think that was, per se, automatically a bad number.
And when you mention the economic machine that is the NFL, their TV contracts back in 1986 was for $2.1 billion over a 5-year period from 82 to 86, and most recently that has jumped up to $18 billion in this current contract. So you are exactly on the money.
So that's because of the enormous concentration of power that they have with total control of the game.
In your estimation, throughout the trial, there were claims from ABC, well, from the USFL, that ABC was bullied into not carrying games in the fall. Do you think something like that could certainly happen in what the NFL could do to?
Absolutely, I don't have any doubt about it.
And to clarify what the Sherman Act, the Sherman Antitrust Law Act is, in layman's term, that's basically where the NFL sort of saturates the networks with their product and they can't deal with another league?
Well, basically, it's when a group of businesses, in this case the NFL teams, gather together and conspire or agree to control the market and to use their economic power to eliminate any freedom within that market. You have to use both the Sherman and the Clayton Acts, and the theory, the legal theory that Meyerson had, to me, was a flawless theory. Proving it is where he fell down. But you have to show that there was an agreement among all the teams, which obviously there was, that the agreement included using their leverage to control the market and to keep competition out of the market, and that the competitor, the USFL, was injured in the process.
So you're saying the theory was flawless?
Yes.
But to give it some sort of damages couldn't be done, you're saying?
Yeah, he failed in proving the injury to his client, the USFL.
How does the Sports Broadcasting Act fall into the Clayton Act and the Anti-Sherman Act? Because they're still...
Good question. The Sports Broadcasting Act is what allows the National Football League to... how many teams do we have now? 32?
We have 32 teams now.
Okay. So now, because of the Sports Broadcasting Act, the 32 teams are allowed to split the television proceeds equally. Obviously, they're a monopoly. Obviously, gathering together and splitting up the market that way would be an antitrust violation. But because of the Sports Broadcasting Act, the National Football League, for television broadcasts, is allowed to split the money in 32 equal fractions, something they could not do without the Sports Broadcasting Act.
Isn't that originally, though, just for the networks and was not supposed to include cable television?
There was no cable at the time it was enacted, so you could argue that it does not include cable.
And I was talking to a recent USFL executive, and he says even till this day, the NFL has the blemish of the anti-Sherman case against them, the verdict, and also they are, in fact, today still in violation of the Sports Broadcasting Act.
They definitely are a monopoly, and they've been adjudicated a monopoly many times, and you could call that a blemish. I agree. Whether it's a violation of the Sports Broadcasting Act is a close call. I would think that in a trial, yes, they are in violation, but it's more like 51 to 49. It's not, 9 to 1. Mm-hmm. It's a close call.
As reviewing the case that you've
done...
The
guy to talk to about that, by the way, is Ed Garvey, who was the leader of the union at the time the Sports Broadcasting Act was written and adopted. He knows more about this than anybody, and he certainly understands. Have you talked to him yet?
I have not, no.
Okay, he's in Madison, Wisconsin. Hold on, let me give you his number here.
Okay.
The terrific guy.
I remember the name, certainly. I
yeah,
definitely...
he was Upshaw's predecessor.
Sure, okay.
And Okay, 608 256
256.
1003.
Okay.
He's a lawyer in Madison, Wisconsin.
Okay, I'll definitely give him a call.
But you got to talk to him.
Yeah, I just want to
And he knows about the USFL trial also.
I'm sure he was watching with keen interest because, he wanted it meant more money for the players.
Yeah.
So it would have been it was a better world. Let me read you something that Judge Leger said in regards to Al Davis, who's won some battles with the NFL, and this is what he said: the NFL's habitual disregard of antitrust advice. Leger, this is on Al Davis's testimony, because his testimony as to 3 or 4 episodes over a 20-year period was hardly sufficient to conclude that a pattern of behavior exists with respect to the conduct at issue at hand. Now, when you hear a statement like that, 4 violations over 20 years, that kind of seems to the average person anyway, to the reasonable person, that is kind of repetitive, wouldn't you not think?
Yeah, there's no question. I don't think that the National Football League knows it's a monopoly. They thrive on it. They glory in it. It is the basis for the success of the National Football League. And to me, and this applies even to the USFL case, let's say that Meyerson and Trump had succeeded in persuading the jury that they had been injured for a mere $800 million. That would be $2.4 billion when you triple it. The National Football League would have continued to fight that case year after year, and ultimately, if they ever had to pay it, each team pays its fraction. So whatever there was back then, 28 teams, you only pay 1/28th. And the owners and the commissioner, and this includes both Rozelle and Tagliabue, they view treble damages as a cost of doing business. They don't care. So when it comes to a monopoly as powerful as the NFL, the antitrust laws, which have, eliminated electric companies and everything else, the antitrust laws do not work.
In saying that now, do you think the NFL, and what you've read over the years and working in the sports business, that the NFL actually more feared the USFL as being its competition, so when they brought the case against them, they were more of the sense, we win either way?
That's right. Yep.
So you think that would be a fair assessment of it?
Absolutely.
Yeah, okay.
Absolutely.
And do you think, what's your feelings as far as the whole NFL, as far as their thoughts towards the USFL, just that they were the competition and they were out to destroy them in a sense?
They view, the NFL must be a monopoly or it cannot succeed to the extent that the owners want to succeed. So it is essential for the owners either to crush any competition or to bring it in as they did the original American Football League.
And do you think that a rebel league could succeed in baseball, basketball, or hockey?
Right now?
Yes.
I don't think, definitely could not succeed in baseball, could not succeed against the NFL, maybe basketball and hockey.
Maybe.
Okay. But it would have to be incredibly well-financed, and the problem would be arenas and television contracts. But I think that the NHL and the NBA are vulnerable enough that, yes, a rival could, if nothing else, stay alive and end up merging into the older league. And just like the AFL.
Right. As you understand it, a lot of the USFL teams had contracts with the stadiums. So I was talking to Jim Moore, the Philadelphia Stars at the time, and he told me once they decided to go to the fall that the Veterans Stadium kicked them out of their offices.
Right.
Is that because in their contract they were supposed to stay in the spring as opposed to moving to a fall schedule?
I'm not sure how that works. Chances are It depends on each stadium, but chances are the stadium had a deal with the NFL tenant that said, during our season, we get that stadium 7 days a week. You cannot have anything in there except maybe a concert, maybe a soccer game, maybe a big birthday party or something. But basically, the NFL in its stadium deals wants total control of the arena, of the venue, for the entire year, and especially during the 18 weeks of the season.
And as we've seen now over the years, in the 60s was the AFL, then the 80s the USFL, and it certainly looks like now the NFL has tidied up any possible threat. A lot of the NFL teams own the stadiums. They've bought arena football teams. They pretty much have a contract with the networks ABC, NBC, CBS, ESPN. So, in a way, the NFL is pretty much blocking any attempt at any rogue league coming around right now at this point.
Absolutely.
Especially by owning the stadiums. You agree with that?
That's a totally accurate summary.
Okay.
Totally accurate. And even if they don't own them, they have such control over them. A lot of these new ones, Soldier Field here in Chicago, where I am, it is completely a Bears stadium. Nobody can do anything there without the Bears going along with it. And it is designed and built to be an NFL stadium, even though it's publicly owned. So even if you don't own it, they have total control of it, which is what happened here, thanks to our mayor capitulating for some unknown reason and going along with this.